So, Chapter 24, we're going to talk about land use, constitution, and the plan. Again, we buy a piece of real estate. We assume that we buy that piece of real estate. We can live there and do whatever we want. But whatever we want and how we use our piece of property is contingent upon land use, zoning, and things like that. So there's a lot to be learned from this. So we have private restrictions on land use. Although most Americans claim the idea of absolute ownership of rights in our land, those rights have eroded sharply in the 20th century. So private restrictions, that's when somebody builds a subdivision, they put their little monument on the subdivision, and when you buy a lot in that subdivision, you're handed a piece of paper that say, these are all the rules and regulations of living in this subdivision. They're not necessarily, they should conform to zoning, but they're more restrictive than zoning. In other words, they say, you can't park an RV here, you can't put this kind of fence up, your house has to have these kind of shingles, it has to be this kind of color to live in this neighborhood. And the reason these private restrictions are legal is because they're trying to preserve the look and appearance of the neighborhood and preserve the property values of everybody that lives in the neighborhood. So these restrictions, these private restrictions, are totally legal, but they stay with the land. Once they're put on the land, they stay with the land forever, like an easement, but they're property restrictions.
Now we get those through the zoning board?
No, you get those when you go buy your house in that community. You get your paperwork as part of your closing documents, your CC&Rs. Your restrictive covenants come with your closing documents, with your title work to your house.
I got a question. Like in our subdivision, it has covenants stuff on there, but there's no homeowners association.
Don't have to have it.
That enforces that. So how? I mean, I know other people that HOA, they send them letters and everything.
Oh yeah, the HLAs are very active.
Yeah, kind of really nobody.
How old is your subdivision?
In the 80s, I guess.
Okay, and some of the subdivisions are even older, and they were done before there was these things called HOAs. The developer just went in and put these restrictions in and said, this is what my neighborhood is going to look like. And that's what you bought into. But they don't charge a fee. There's no planted garden or anything at the front entrance. But your restrictive covenants should be part of your title, your deed paperwork. And what happens is when somebody does an infraction against what it is, it's up to another homeowner to bring an action against them.
So there's no policing model. It's just somebody else.
They don't have to sue them. They go to the building department and say what they're doing is illegal. What they're doing is wrong. Yeah, okay, well, they didn't pull a permit, but what they're doing is against what we're allowed to do in the neighborhood. So they go to the building, the city, and say, help me get this person to act right. They may say, I'm sorry, we can't help you. It's a private thing. You better hire an attorney. They could say that. On the other hand, they can come back and say, well, what's our zoning law? What do we have today? Because there's a lot of these restrictions that are comparable and reflect what is zoning. What is the building code? What's allowed? Now, in my neighborhood, we're not allowed to have garages on corner lots. You're not allowed to have a garage on a corner lot because there's not enough setback off the corner to get it back into the property the way our setback is supposed to be off the front of the street. The lots aren't big enough. Our lots are 100 feet deep, but only 40 feet wide. And our lots say that a garage has to be 60 feet back. Well, you can't do it on a corner lot that's only 40 feet wide. So what they did is they came back and said, no more garages on corner lots. That's the new zoning code. Now, if you live in a corner lot and you have a garage, that's precious, buddy. You do everything you can to preserve that garage. But the people that want to build garages can't. They can't build new structures because it's. But again, there's a zoning that says that. That's not part of our property restrictions. But that would be the kind of thing that somebody might write in a restrictive covenant. So yeah, it's up to the owners around. If you have enough people that voice discontent, somebody might correct what they're doing. No, there's not an easy answer to that. With an HOA, you have a group that can come in forcefully and do it. But without an HOA, it's just up to individual property owners to look. So the private agreements are usually placed in the deed by the seller when conveying the land to the buyer that restrict future use of the land. So again, this is a subdivision developer saying, I want them to all look like this. Now, he may be the builder as well, or he may just be the subdivision developer. But he put forth these rules. The privity of estates, a phrase used to express a successful relationship with the party to the land. The term touch and concern of land relates to the determination of whether the purported easement is peculiarly tied to the land itself or is rather a personal agreement between the parties and only incidentally concern the land. So again, you've got these restrictive covenants. They stay with the land. Eventually, sometimes they get pulled off